Hi everyone, Michael McVety, President of Red Fortress Property Management here to do a very quick video about an important legal update for property managers and landlords in the state of Florida. It's coming up shortly that we have to implement some things, some new systems if you want to be compliant with the law. So I thought I'd do a very quick video on it. And this is the new Florida flood disclosure law that just came into effect. It was passed June 20th of this year, 2025, and it's coming into effect next week, October 1. Okay, so right around the corner, a week away. So let's talk about this bill. So it starts with Florida Senate Bill 948. And what it's really designed to do is it creates a Florida statute, 83.512, which is pretty exciting. But what it does is it mandates landlords, even developers and other people, to provide a history of flood disclosure history about the property. Okay, so first of all, the language of this actual disclosure is in the law, so you don't have to make words up or try to be cool with legalese or something. It's already there, so that's really useful for us. In addition, as a big oversight before we get into the law, it has to be done at the time or before the actual execution of a lease. So this isn't something that you offer it afterwards. It's something that during the application process or when you're about to sit down and do the lease, it has to be signed at least time or even before. And then another big aspect of it is that it's got to be an actual separate addendum. So you don't get to bury this in the lease somewhere. You know, your lease is, I don't know, 60 pages or something like that. You kind of bury it in page 45 with like small print. No, you don't want to do that at all. The exact opposite. It's a very simple addendum, and it really does go to the way to help our renters. Okay, so what does the addendum say? And again, remember, this is state law, so I'm not making this up. It's not something that I just did. It's actually in the law. So the first thing that it does is it talks about the flood disclosure, and it talks about that this disclosure is going to be made by the landlord, the person that owns the property, pursuant to this new Florida statute, and it's talking about the property. And what it does is it goes into a preamble and just basically saying to the renter, hey, listen, you might have renter's insurance, but most of the time, it doesn't include flood insurance. In fact, rarely does it include flood insurance. Most of the time, you might be saying, well, hey, listen, my renters, I think all of them have renter's insurance. True, but normally that's dealing with general liability and maybe contents for the renter. Very rarely, if ever, does it deal with flood. Okay, it's the same thing, by the way, for our clients or landlords. They might have all kinds of different types of insurance. But remember, flood insurance for the property owner is also voluntary, okay? And most people don't, until recently, they didn't even bother with it. Obviously, with hurricanes like Ian, that changed a lot of people's mind and also changed the flood zones and the effect of flood insurance on a lot of properties and rental units. So that's a different subject, though. But so it asks basically three questions from the owner of the property. It says basically, first of all, hey, Mark 1, do you know whether there's been flooding on the property? Yes or no? Like, landlord has knowledge of any flooding that's damaged the dwelling unit. Okay, so that's the first question. Has there ever been any flooding to your knowledge? And then second of all, has there ever been a claim with insurance regarding the property and flooding? Okay, this is question two. Part three, or question three of the addendum is, has the landlord ever received flood insurance or help through, say, for instance, somebody like FEMA? So the three questions are basically, hey, to your knowledge, has the owner of the property, have you ever had flood damage to it? Have you ever filed an insurance claim for it? And third question, have you ever had flood assistance given to you for the property? And then the next thing that it goes into is it describes actually what the term flood means, okay? And it talks about obviously inland or tidal waters. It talks also about how you can have accumulation or rapid accumulation that is maybe in a drainage ditch that overflows and comes into your unit. And then it also talks about sustained periods of standing water that resulting from rainfall. And this is a really important aspect, especially for people in the coastal areas like I am in Florida, like Southwest Florida. We often think that flooding happens during hurricanes. In actuality, it doesn't. We get a lot of severe storms, tropical storms in the state of Florida. I know that this year alone in 2025, even though, knock on wood, we haven't had any hurricanes here in the state of Florida, but we did have flooding. So a couple of weeks ago, or about a month ago, we had flooding in St. James City and Sanibel. There was about 7 inches of water that came down. It was almost like Hurricane Ian for some parts of Florida. That happened like overnight. And so we had flooding even in Sanibel and St. James City without a hurricane. So don't think that flooding happens only because you have a hurricane warning. All right. So finally, the last part of the addendum goes into the certificate of acknowledgement, where basically the landlord and the tenant are talking about this disclosure, that it's done prior to the lease agreement and that this is an addendum. Okay. And so I also want to always thank the people that provide a lot of the information for this, the law offices of Heist, Weiss, and Woke. Again, you can go to their website, evict.com, and you can get some of this information. They're always great. They have videos. They're fantastic. So let's talk a little bit about implementation, and then we'll follow up with what happens if you actually don't do this disclosure. So first of all, when you're talking about implementation as a property manager or say as a landlord, it's a lot easier because you're not, you're by yourself. You don't have to work with other people like property managers do. So if you're a property manager, you want to talk to your client about their property. So let's just say that you have a property that's on the market right now, that's a vacant unit. You want to talk with your current owner and say, hey, listen, we have this new disclosure coming, and we have to get this signed, this new Florida law starting next week. Have you, ask them the questions. Have you ever had flooding? Have you ever filed an insurance for flood? That sort of thing. Now, one of the major things about this is it talks about the current ownership. So they're saying, hey, listen, like you don't know what happened 25 years ago during, Hurricane Charlie or something like that. So if you didn't own it back then, you're not necessarily going to know. But if you do, as an owner or as a property manager, know that this property's flooded before, you want to bring that to the forefront. You want to let the renter know that floods have happened before on the property, and this way they can get the appropriate insurance that they're notified. Okay. So talk to your client about the flood history. You also want to get that form and then put it either physically in the owner's file, or if you have like an electronic file for the owner as well, put it there, save it, that sort of thing, back it up. Make sure that you have this for all intents and purposes if there's ever like some type of audit. Then you look also into the past flooding history. You can look for insurance claims or even FEMA assistance. This is hard to look up online, but maybe you can talk with insurance companies, if you need to, that sort of thing. But certainly the best point of contact is the owner themselves. Then after the new addendum signed by the renter as part of your leasing process, and that, by the way, includes your lease renewals. So granted, you might start look at, like we are, our new vacant properties. Let's do those first, get them taken care of. But when you're starting to have lease renewals coming up in November and December and that, you also want to reach out to those owners and get that ball rolling. So when you do a lease renewal, you also have this disclosure available for the lease renewal. Okay. And then once you get that signed by the renter, again, put it in the renter's physical file, back it up electronically, put it in an electronic folder, whatever you have to keep it on file. You want to go from there. So the question is, what happens then if you don't do this? What happens if, as a Florida property manager, you don't reach out to your clients? There's no disclosure sign. That's going to be opening up yourself, obviously, to liability, because if something does happen with in terms of a hurricane or some type of tropical storm or depression, and you do have flooding, and it's happened before, that's going to start opening up you and your owner into a lot of liability, right? Because you knew about it before, you didn't disclose it. You can see where we're going with this, right? So first thing that can happen is if there's flooding with this new law, the renter can terminate their lease up to that point if there's substantial damage. So the way that the law reads is that if there's 50% of the person's value of their property is damaged by flooding, they can leave. Okay. Now, I mean, how are we going to decide this? Is there some kind of appraiser going in there? No, not at all. I think that we hopefully use some common sense. If somebody has that much damage that's occurring by flooding to the property, then obviously, we don't want to split hairs as property managers. You want to do the right thing and let the renter out and go to a different property, because if you're going to have that much damage to personal property, chances are there's probably going to have to be a lot of repairs done. But the way the law reads is that they could, legally offer to terminate the lease if they've had substantial damage to their personal effects. And then any type of advance rent and or deposit would be returned to the renter after they obviously turn in the keys and give back possession and they only owe what they owe prior to the flooding. So if they had some kind of balance that they hadn't paid, that's the only thing that's owed. There's not new charges tacked on. And so finally, if you'd like to send me an email regarding your procedures or you have some thoughts on this, it's a new law that's coming into effect. Obviously, when new laws get passed, you never know how they're going to work out when they get challenged by attorneys and so forth. But just want to bring everybody's attention to this. October 1 coming next week. And please have these disclosures set up, start working on it, and we'll see you next time. Any questions, reach out to me. Have a wonderful day. Take care, guys.